Sorry for the delay here. We're just going to wait until we get quorum, and then we'll gavel in, and we'll get started right away. I know the House members are going back in at 2:30. I think that's right, so we'll try to move things along shortly. All right, we're going to get started here. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, April 1st, 2026.
Oh, okay.
We have 14 bills on the docket, and we're going to start off with Delegate Stewart with, actually, no, we're going to do Delegate Phillips and then Delegate Stewart next, okay? So we're going to, House Bill 16. Is Delegate Phillips here? All right, then we're going to start off with Delegate Stewart with House Bill 1018.
Senate Bill 1018. There you are.
Thank you very much, Mr. Chair. Members of the Illustrious Proceedings Committee, my name is Stewart. House Bill 1018. This bill has to do with jails, and it deals with the issue of when a jail fails, whether it's because of a medical breakdown or a power loss or a fire risk or a lack of an emergency plan, and what that looks like. Because we know that when a jail breaks down in some way, the consequences of that breakdown don't stay inside the parameters of the jail. They end up falling on taxpayers, on ratepayers, on hospitals, on EMS crews, and on first responders. And so this bill is designed to reduce that risk, the risk that preventable facility failures become public emergencies and therefore public expenses. And so what this bill does is four things. It makes clear that minimum safety and health standards apply to all covered custodial facilities in the state, all jails. Second, it strengthens reporting and inspection requirements over all of our jails. Third, it creates a yearly readiness checkpoint that's focused on infrastructure capacity and emergency capacity. And fourth, it provides enforcement tools and allows inspectors access to these facilities to ensure that operations are complying with the law. This is a bill that received bipartisan support over in the House. I believe that you guys did have the Senate bill over here. It was initially in the Rules Committee and it was pulled out, but then the hearing was canceled. So it's the first time that y'all are hearing this, even though you do have the Senate bill, which is cross-filed by your chairman. I'm hoping for favorable consideration of HB 1018.
Okay, thank you, Delegate. Any questions? Senator Henson.
Thank you. Delegate, is your tie made of Legos?
It is, Delegate. I mean, Senator, it is. I almost demoted you. Senator Henson, it is made of Lego. I am very proud to serve on the new Lego committee in the House of Delegates, and I had a very enterprising staffer who made this entirely Lego tie. So it is a little bit of a silly tie and a very serious bill.
Wonderful. Thank you.
Thank you,
Mr. Chair.
I told him on the elevator that was a great time that I wanted it. He said no.
It's going to come apart at any point, so I'm glad to get that recognition before it completely collapses in front of you.
Any other questions? Thank you very much.
Oh.
I'm sorry. Oh, I didn't look. I'm sorry. I'm sorry.
I'm on the left.
Oh, okay, I'll call you. Senator West on the left.
Not for the only time, Senator West.
No, you're right. Occasionally I'm on the left.
Yeah, exactly.
Thank you for bringing the bill, Delegate. But tell me, currently, the Department of Corrections does have standards that apply to the prisons, and it doesn't the Department of Corrections make sure that the prisons in the Maryland comply with the applicable standards? So what does this bill, what additional standards would this bill deploy that are not currently in effect?
Yes, I appreciate that. So first, the bill applies those existing standards for jails to immigration detention facilities, so that all locked custodial operations in the state have to operate by the same standards. So that's the first move it makes. But then secondly, it strengthens the teeth for all of those types of jails. So it creates a new reporting channel. It strengthens whistleblower protections, again, for all jails, so that people who are inside the jails, including private contractors, can be protected if they come to the state and report that violations are happening in that particular jail. And then it also creates what I'm calling a yearly readiness checkpoint. But basically every jail in the state, including immigration detention facilities, would have to report annually to the state about their capacity for infrastructure, their emergency readiness plan, and the impact that they might have on, for example, first responders and EMS if there was a breakdown.
Okay, 2 more questions. First of all, what position did the Department of Corrections take on this bill?
We worked with them proactively. I think they actually do have a couple of late-breaking amendments now that it's over here, but we worked with them. They took ultimately no position on the bill in terms of putting something into the bill file, but we worked with them on amendments on the House side to make sure that this was something they could do without any additional fiscal note.
Okay, you say they have some additional amendments that they're
They do, and I have submitted
would like us to adopt?
That's correct. They have an additional couple late-breaking amendments that we didn't have time to adopt on the House side, just to basically make this more manageable for them and make sure this doesn't drive up the cost.
Okay, and do we have copies of those amendments?
I believe that the cross-file your chairman does, but I'll make sure the entire committee does as well.
Okay, and finally, I note the fiscal note says the bill may result in a significant increase in general fund expenditures. Do we have any idea how much of an increase we're talking about?
So we worked with the agency. They believe that they can do this with the amendments that we're going to offer here on the Senate side. They can do this with maybe just an additional 2 or 3 pins, and that would be the entire cost of the fiscal note. So
Doesn't sound like a significant increase.
No, I don't think so. But again, that goes to the amendments to make sure they can do this. The goal here is to make sure that every jail, no matter who it houses or what the purpose is, just operates based on very minimal health and safety standards. But we want to do it in a way that the agency can actually comply and can do it with more or less, give or take a couple of pins, their existing resources.
Yeah, good. And finally, can I just commend you for a bill which would not only regulate the facilities operated in Maryland, if there should be any, by ICE, but also in exactly the same way, would apply the same regulations to Maryland facilities. I think this kind of a bill could withstand constitutional challenge, as opposed to other bills which simply direct themselves to regulating the federal operations in Maryland and do not subject Maryland facilities to the same level of regulation. So I think this is good. Thank you.
Appreciate that.
Okay, any other? Yes. Senator McKay.
Thank you, Delegate, for bringing the bill. So given that there are no immigration detention facilities currently operating in the state of Maryland, but the note indicates that for federal proposals that are under consideration, do you know how the department will plan staffing, inspection capacity, and implementation timelines when the number and the size of such facilities can't be yet identified reliably?
It's a great point, Mr. Senator, which is that obviously we have a lot more control over our existing state prisons and when we put them online and how fast they accumulate than we do federal facilities. We also don't know, to Senator West's point, exactly how much of the bill would apply to purely federal facilities. For example, I know there's one in Western Maryland, and we've gotten an Attorney General letter about which parts of the bill would apply to that facility and which one wouldn't based on the private or the federal nature of that. And I think some of that still has to be worked out. It's possible that if there is indeed an explosion on immigration detention facilities outside of our control, that we can legally regulate as a state. It's possible we'll have to come back and look at this fiscal note in future years and assess whether or not, as a state, we can take on the additional burden of what this bill seeks to do.
Okay. If you would be willing to share that, Attorney General.
Oh, yeah, of course, absolutely. Absolutely. And yeah, and the general gist of it is that the bill is not clearly unconstitutional. And to Senator West's point, we very carefully calibrated this bill with some existing jurisprudence out of the Ninth Circuit to try to make sure that it's very clearly on the right side of the Constitution.
Thank you, sir.
Thank you
very much.
Okay, Senator James.
Yes, thank you, Delegate. Just following up with the 2 gentlemen, I too want to see that Attorney General's opinion, because my initial, and I apologize, I came in a moment, I was here early, but then I stepped out, so I didn't hear the beginning. But my first reaction was that it might actually violate the Constitution simply because we're now legislating in an area that I think the federal government has supremacy over us. So, and when the Attorney General says something clearly not unconstitutional, that is legally speak for it's pretty dicey, pretty questionable whether it is constitutional. That's what the import of that language. So I'd like to see the opinion, because it sounds like what you're saying is the Attorney General may have found some aspects of the bill might pass constitutional muster, others might not. And then you indicated that there was a Ninth Circuit jurisprudence that you were looking at. Would you share that with us as well? So that we can take a look at that?
Absolutely, Senator, and I appreciate that. And what I would say is that, yes, the letter basically says that parts of the bill are more constitutionally risky than others. I believe that not clearly unconstitutional standard, while you're right, it sounds like it's not the biggest endorsement of all time, is the general standard that the AG uses. And while they did note that the law around this topic is still very much developing, what they pointed out is consistent with essentially these two twin Ninth Circuit cases. One is the Newsom case, which, as you might have guessed, was named after the California governor. One is the Inslee case, which was named after the Washington governor. And those contrasting cases kind of show what is and is not permissible under the Supremacy Clause. When states try to single out the federal government in particular and try to do federal immigration policy from a state legislature, as Senator West noted, they very, very quickly start running into problems with the Supremacy Clause because we can't do immigration policy. We can't do federal immigration policy, and we can't necessarily tell the federal government specifically what to do and single them out. But what we can do, per the Inslee opinion and per the Attorney General's letter, is create basic health and safety standards that apply to all jails in our state, as long as they're neutrally applied to all jails and not targeting the federal government in particular. But I'm very happy to share both opinions as well as the Attorney General letter with the committee so that we can all be on the same page.
I don't want to get an argument with you, but I'm just telling you, the Attorney General says that it's not clearly unconstitutional, that it is not an endorsement, that it is constitutional.
Fair, totally. And to your point, there are different, the bill is relatively large. There are different paragraphs, as you'll see in the Attorney General's letter, where some stuff they say, good to go. Other stuff is kind of, we're not totally sure, to your point. Yep.
Thank you. Any other questions? Thank you, Delegate. I believe we have one more. We have one favorable witness.
Okay.
Amendment.
Thank you all very much.
You gotta call them up.
I didn't give me that. I don't know. Where is it?
Here.
Okay, Anita Bath. You here, Anita Bath? Thank you. Time for my lunch.
That was a slow burn right there, man. My God. All right. Seeing no further witnesses, thank you very much, Delegate Stewart. That'll conclude the hearing for House Bill 1018. Thank you for the prompting over there. All right, we'll now go on. Is Delegate Phillips here? All right, then we're going to go to Delegate Guyton. You're next. Welcome.
What would you prefer? Okay, thank you, and thank you, Delegate Phillips. Thank you, Mr. Chair, friends on the Judicial Proceedings Committee. I appreciate you hearing out my bill today, House Bill 646. It's pretty simple. This bill passed unanimously in the House. It is bipartisan in nature, both in committee and on the floor, and by co-sponsors. And what this bill attempts to solve is a problem that happens when people who are actually respecting the law, unlike some who do not, follow the law when they reapply for driver's licenses and tell the MVA that they've been diagnosed with a certain, one of the many, many conditions that you have to report under the law. Now, this is self-reporting, but if you don't do it, you're considered on the wrong side of the law. And the problem that we discovered dealing with several constituents, both my chair who originally brought this bill to me and then in my own district, is that folks who are going through this find that the response of the MVA, and I've worked with them closely on this bill, so we're all on the same page and we're all friends now, but the response of the MVA in these situations is very inconsistent, is incredibly time-consuming, and it's all through the mail, right? So you fill out the form when you're trying to get your driver's license renewed. A few weeks later, or even later than that, you may get a packet in the mail to say, have your doctor fill out these forms. You have to send it back to them. You may then have to have more testing. It is an onerous procedure to actually follow the law. Right? So what this bill does is a couple of things. Number one, it says that in these cases, if you present a doctor's note and report from the doctor that's treating you for this condition, and it knows you, right, that says this would not impact your driving, that is not the only thing MVA has to consider, but they do have to consider it more strongly than any of the other information in front of them at that time. Right. This bill does authorize them, if they're concerned, to collect more information, but they need to put more clout in that report from the doctor who is treating you for that particular issue. The next thing this bill does, it actually set up an expedited permitting system, because there are people who may have to take the test again, but they haven't had ever driver's license classes. I never had to in my state, right? Or they haven't had to take the test for 30, 40, 50 years, some of them, right? And yet they have to take the test. It's virtually impossible for them to get a permit to go take those lessons and take the test. So this expedites that process as well for those folks. And then what is probably the most impactful, after many conversations with MVA about the fact that the process was really a case-by-case basis and did not have a lot of consistency throughout, is that they have decided on their own to amend this bill to basically require them to do an audit of their own services, and you'll see that in the amendment, that they have to look at their own administrative policies and report back to us by December 1st of 2026, how they're going to bring those into the 20th century, how they're going to do it digitally, and how they're going to expedite some of these processes for the people who are actually could easily decide not to follow the law, but who are actually doing so. So that's the bill, and I hope I can count on your support for House Bill 646.
Thank you very much, Delegate. Questions from the committee? Senator West and then Senator McKay.
Thank you, Mr. Chair. First of all, I want to compliment the delegate for bringing this bill. The delegate probably represents the best legislative district in the state.
Certainly do.
And she's the best Democratic delegate representing that district, and the only. So I just want to commend the bill. It sounds like a great bill, well conceived and well presented. Thank you.
Thank you, sir.
Thank you, Delegate, for bringing the bill. So the legislature, the legislation mandates an expedited process. So my question has to do, the criteria says that the MVA may define what acceptable reasonable period is. Has there been any kind of context of what exactly reasonable period is?
Yes, we had a lot of conversations beginning in the interim, way back in the interim on this bill when we were trying to solve particular constituent cases. And that's how we ended up actually with the legislation, because MVA wanted that legislation also to push them forward, which is why you have no opposition to this bill. We did have conversations about that. Rather than mandate it in this bill, though, we are putting some faith in them based on those conversations that they are going to improve that. And we certainly have also written into the bill that they have to have a very particular plan by December 1st, 2026 to ensure, to trust but verify. Right?
Thank you very much. Good quote.
Thank you.
All right, further questions from the committee? Senator James.
Okay, Delegate. I don't have, for some reason in my file, I don't have the fiscal notes, so I don't know what the medical conditions are that are already enunciated in regulations. Could you share, could you just give me a run? If it's not long, go ahead.
Sure, it is a pretty extensive list, and I don't have it in front of me. It is online.
Give me a sense of it, just a sense.
Things like sleep apnea, but where this bill particularly comes into play is with the other category. Other things that might impact, right? And I'll just give you an example of the issues that we've dealt with. One was a peripheral neuropathy, which was a tingling, a neuropathy in the external fingers and arms, which falls under neurological difficulties that they had to report. However, that particular issue did not in any way affect their driving, and yet they had to go through this whole process.
They had to because that particular condition was enunciated in the regulations?
Neurological conditions, yes.
Okay, so sleep apnea, and then you're like a lot of.
It could be eyesight, there are a lot of different things.
particulars, but then there's a catch-all, excuse me, at
Certainly.
the end that says other things that might impact driving. So, okay. So I'll take a look at those regulations. All right, thank you, Deb.
Thank you so much. And if you'd like for me to send them, I can do that as
I
well,
would.
but they are.
That'd be
Okay,
great. Thank you.
Senator Folden.
Thank you.
Oh, I'm done.
I just wanted to, thank you for the bill, Delegate. I just wanted to find out, so sleep apnea is something that people have to self-report?
Yes, sir, it is.
Not, oh. So I'm just curious, that's in legislation now?
It's in regulation, I believe. I'm not sure it's
Or
in statute, yes.
regulation now that sleep apnea, you have to report, self-report?
And if I might, Mr. Chair, to respond to that more, we actually had a separate bill on sleep apnea this year with another delegate bringing a bill to try to exempt that from this process. However, we felt like the work that we did in this one also addressed that one, because what we want to do is make sure that people are comfortable getting treatment. And the reason he was exempting them is because he was afraid that they wouldn't get the treatment and be diagnosed if they felt like they had to diagnose it. This way, if you're getting treatment, you're getting the care you need to make sure you're safe on the road, then your doctor can vouch for you and you're more likely to also get the treatment. So they will also be affected by this bill. Although I will say the NBA has a specifically different expedited process for sleep apnea in particular.
So that's what I was going to ask. Don't they already, haven't they already been doing something like this process already at the MVA?
They do have it for sleep apnea, but not to this extent. No, they've been doing some of this. This is where some of the language came from.
So, okay, this, and I apologize for
Sure.
coming in late, but so if someone has sleep apnea and they don't report it,
They're just not following the law, but obviously we can't, if they have an accident,
following the
perhaps
law.
they can be, yeah.
so we don't have, so sleep apnea, like, I'm thinking about sleep apnea, how does that have any relevance to my driving ability?
Actually, it does, and I'm sorry if anyone in this room has sleep apnea, many of us do. It does actually impact driving, particularly sleepiness on the road. So there is a lot of institutional and insurance data showing that people with sleep apnea, if untreated, and particularly, are more at risk for accidents. And the NBA has picked up on that and includes that in their reporting requirements.
So like, and I'm sure like type 1 diabetics is in this,
I do not know. I'd have to go back and look at that list. I do not know.
so I'd like to see that list because it's
Sure.
interesting to me that type 1 diabetics is something that I've actually been involved with through different processes of my own family, but I've seen other crashes as well from people that blood sugar goes low and they have a diabetic attack. So, okay, if you can just, I would like that
Sure.
data also.
Absolutely.
I appreciate
Should we
it.
send that to the committee or to the individual?
Yeah.
Oh, okay, great. Thank you so much, Mr. Chair.
Because my opinion is, quite honestly, it's none of the MVA's business. So I'll just tell you.
Certainly,
I mean,
that's
I'm
not
just
in the
curious,
bill, but. yeah.
What, I mean, what business is it, as long as I'm being treated, what business is it of the states, what my health conditions are
Sure.
or are not?
Sure, and
none of their
that
business.
was something that was already in regulations, so that wasn't.
Okay.
We're just trying to make it easier for people, you know,
Okay,
like
thank-
that example that you just gave, to actually get through the process without breaking the law.
All right, thank you.
And thank you for bringing the bill. Just one question, two questions based on what my colleague brought up. Would you be amenable to any amendment? Would you be amenable to any amendment that would, number one, either take it out, sleep apnea, take that out, or streamline it a little bit? That, I mean, we can talk about that. But again, I don't really think that. Then,
Sure.
I mean, you might talk about those being treated as opposed to those who are not being treated. But I don't think anybody with sleep apnea who is under doctor's care, that they should just come up and report that.
Sure, and that, thank you, and that is exactly why the bill is written the way it is to also address the sleep apnea piece, which was brought before our committee. So sleep apnea is very dangerous in driving, and obviously you'll do your own research if you feel like doing so, but I can share that too, if you are not treated. And I hear you saying, if you're treated, it shouldn't be a problem. This bill makes it not a problem, because if you have a doctor saying, I'm treating him for this, he's not dangerous, then that would be the primary determining factor in this decision.
Yeah, okay.
Right.
Unless, I
Sure.
thank you for that.
Yeah.
Just want to look into that a little more because I really don't
course.
think that that should be a part of it at all.
Yeah.
Thank you.
Yeah, unfortunately, the data does show that sleep apnea is a problem if it's not treated, so.
Thank you so much.
I'm asleep at the wheel. I should have asked you this.
Nice pun, Senator.
You know, I try. I'll be at the, the Rams head on Friday. I just realized that I have another issue, and this isn't about your bill, but you may know about this. So I have a problem myself with, disclosing medical information to unnecessary groups. So I don't know whether you've looked at this, but I would probably want an amendment on this bill if there's not already something ironclad, that this remains confidential, that in no way, because usually if you release it, then you have broken the confidentiality. And I have no regard for MVA or any other large government institution being able to keep your information private. When you were doing this, were you aware, did you see some information about their obligations for privacy in terms of revealing this to this?
Yes, Senator, and I love that question because you may or may not know I've done a lot of disabilities advocacy work over the years, and so that's always a primary concern of mine as well.
Right.
Yes, the only actual information, other than one instance during a subcommittee meeting where something was shared that probably shouldn't have been shared. The only information that is allowable is that information that came from the constituents that came to us. So they were not sharing anything from the MBA or from the Medical Advisory Board that they're not allowed to do that. And so that was part of the conversation, and they assure us that they cannot. If you want to strengthen that, I have no problem with that, but I believe that the privacy aspect is not something I've heard of as an issue before.
Yes, and I just.
But certainly if you want to strengthen it.
This probably existed pre-HIPAA. So
Sure.
my point is that we ought to maybe take a look at this, and if we're going to do this, start it, especially if we're dealing with the health thing, amend the bill to strengthen that privacy obligation and the ramifications should that privacy in any way be violated.
Sure.
So, something to think about. I think it would be important.
I'll ask MVA to maybe
you would ask
contact
them-
you.
Yes, exactly.
Okay,
Thank you,
wonderful. All right, I've got two
Appreciate it.
chores now.
Thank you.
I'm on it. Yes, traumatic brain injury.
No, I know.
Yeah, okay.
I know that's a parallel issue, ancillary issue, but, so you did mention Delegate Kerr's bill. Are you all
Yes.
moving? I mean, it's after crossover now, but
Yes.
were you all thinking about moving that, or?
We felt like we addressed those concerns in this bill.
Okay, all right, appreciate it. Further questions from the committee? All right, thank you very much.
All right, thank you all so much, and I will follow up with the information that you requested.
I just gave it to him already. Thank you, though. Yeah, thank you very much. All right, with that, that'll conclude the hearing for House Bill 646. We're now going to move on to Delegate Morgan, and then Phillips, we got you next, but Delegate Morgan's been waiting patiently. So Delegate Morgan with House Bill 668.
Thank you, Chair Smith and committee. Can you hear me up here? Thank you. Good afternoon. I'm Delegate Toby Morgan on behalf of the St. Mary's County Delegation, and we are presenting to you House Bill 688 for the purpose of providing safe roadways for both vehicles and pedestrians. The bill provides that anyone standing in a roadway, median, or roadway or intersection is determined to be inherently dangerous by the county. St. Mary's County is rural in nature, with the exception of a few town centers where the vast majority of our commercial growth has been directed. These are areas that have a few elevated concrete medians, which are found on typical commercial intersections with a state road and do not include crosswalks because we have very few sidewalks. Most of these roads have posted speed limits of 30 miles per hour or more. As traffic increases on these rural highways, the county feels it necessary to address the issue of solicitation in roadways for public safety. On highways which carry most traffic, posted speeds of 55 miles per hour are often exceeded by 10 to 15 miles per hour. And some of these have a high number of accidents. As with many other areas of the state, traffic enforcement is needed, and automated enforcement has been discussed here as a statewide. And as people know, I'm all for automated enforcement. I can't get the commissioners to buy in. However, accident prevention is the best way to keep people safe and traffic flowing. Additionally, there are intersections in the county where we have a high volume of traffic and/or narrow median or shoulder structure, making the intersection inherently dangerous for individuals standing on the roadway. Over the last 2 years, St. Mary has attempted to pass legislation making restrictions on all solicitation and roadways as a way to discourage individuals standing on the medians. However, concerns about the legality of this proposal have kept the bill from even passing, even with the 2024 Attorney General of Maryland opinion finding that content-neutral restrictions were permissible. Therefore, out of continued safety concerns, St. Mary's County is requesting permission to prohibit standing in certain intersections based off its inherently dangerous configuration and/or accident history. We have consulted with the State Highway Department on those proposed intersections, and they are agreeable. The bill will make our intersections and roadways safer for our pedestrians and vehicles, and we're asking for the committee's favorable report.
I'll get questions from the committee.
Thank you, Delegate.
Thank you.
Thank you for giving such a thorough history. All the delegates today have done a wonderful job. I think you're joining other counties, are you not? I'm quickly looking, because I thought, doesn't my own,
The answer is yes,
Hartford
but we've
prohibit this?
Yes, we're joining other counties, but
Okay.
we've gone through significant legal interpretation over the years.
Okay.
And we're tightening up, based upon the most recent federal cases, we're tightening our language to be more consistent with other counties who were a little bit more gracious in their interpretation in previous years.
I see, because what I was thinking, so in other words, I'm looking and because I knew Hartford had some prohibition against this. Are you saying to me that your bill is probably a sort of a better version?
It's better and tighter by statute.
By statute than some of
Yes.
the earlier ones. So something I should take a look at for my own can if I want to kind of tighten it up and make it a little bit better drafted, you think?
That was what I was told by our legal counsel.
Very good. All right, thank you.
Thank you, guys. Have a good day. Happy April Fool's Day. And I want the full day.
Good afternoon. And Delegate Phillips, we'll call up your panel too.
No, I don't believe we have a panel.
Yeah, lunatic,
If I have a panel, come on up.
lunatic.
Happy April Fool's Day to you too. Mr. Chair, is this how a fellow member of the judiciary gets treated?
Oh my gosh, no, that was a witness. I don't know who that witness was. But, all right. We've got one more left, and you know who the senator is going to be the butt of that joke, so we keep it quiet when he comes in here. But all right, but all seriousness, thank you very much, Delegate Phillips, House Bill 16. Welcome.
House Bill 16. Thank you, Mr. Chair. Thank you, members of the Judicial Proceedings Committee. Look, I'm here to respectfully request a favorable report on House Bill 16. House Bill 16 is actually, I'll call it the sister bill, since it is not a cross-file, of Senate Bill 187, which we just heard yesterday on the House side from our leader. Last year, I brought a similar bill that passed out of the House, but was not voted on here in the Senate. And I respect that. You all didn't think it was ready, so that's okay. So I think it's ready this year. So over the summer and the fall, my office worked with the Senator's office, worked with the hearing examiners, communicated with the chair of the Parole Commission and a number of other stakeholders to kind of reform House Bill, what is now known as House Bill 16, which is a targeted, practical reform to strengthen the operations of the Maryland Parole Commission by improving how decisions are made, who is to make those decisions, and how quickly those decisions can occur. At its core, this bill does four things. One is it professionalizes the role of the hearing examiners. Parole decisions are among the most serious determinations made within our criminal justice system. So this bill moves the process toward a more structured, quasi-judicial model, ensuring that hearings are conducted consistently, records are well developed, and recommendations of the commission are grounded in professionalism and expertise. And I want to say once again, working very closely with the hearing examiners. We're trying to, look at who are the hearing examiners. One of the things that we noted is that about 90% of the hearing examiners all came directly out of the criminal justice system. And so we'd like to kind of mix that up a little bit. Second, the bill improves the appointment process for the commission by reinforcing a structured approach to identifying and nominating qualified commissioners. These are critical positions, and this bill ensures that the individuals serving in these roles bring judgment, experience, and balance necessary to protect both public safety and fairness. Third, it addresses vacancies that delay justice. Many of you know when we were here last year, there had to be 10 commissioners. We were operating at 7. It had gotten down to 6. Very happy to report they're now fully staffed with 10 commissioners. However, we want to make sure that if there are unfilled commissioner positions, the code already allows for the secretary to appoint someone temporarily, generally a hearing examiner. This just kind of more codifies it and gives direction on filling those positions temporarily. Fourth, the bill streamlines the decision-making process by allowing parole decisions to be made by a majority vote rather than requiring a fixed number of votes, because currently you have to have at least 6 votes with some of those decisions that the commissioners make. When they were down to a 7-member commission, if 2 commissioners didn't show up, then those potential parolees had to wait until the next meeting. So this makes it requires a plurality. Taken together, these reforms will allow the commission to conduct more hearings, reduce backlogs, and ensure that individuals have earned their consideration receive it in a timely manner. There's also a clear fiscal benefit. If we can improve the process with parole and individuals have their day to be heard and they have qualified people looking at them, and we are able to increase the number of individuals that are paroled, that have earned parole, we'll be saving ourselves considerably in the correction system. And with that, that's pretty much what the bill does. And it, once again, I think, you all know what the senator's bill does. We go a little bit further in some of these reforms of the Parole Commission.
Excellent. Thank you very much, Delegate. Questions from the committee? We'll start off with Senator Folden.
Thank you, Delegate. Good to see you again. So I'm looking through here, and I'm kind of asking, I hear you saying that you seem like you think there's some type of backlog, but I don't see any type of backlog that we're having. This bill seems to be in search of a problem that's not there.
Well, we've had a backlog. The chair has indicated that they are moving through the backlog. The other challenge that we have, go ahead.
That backlog was created by the lack of action by the current Secretary of the Department of Public Safety. That's her. She had the sole responsibility of that, does she not? So that inaction, once again, by that same secretary, much as she did with following the death of the parole agent, created a public safety issue.
One of the things that, to speak to that, currently the person that appoints the commissioners and ensures that we have a full complement is that same secretary. We believe—
Exactly my point.
We believe that this helps to ensure, no matter who the secretary is, that accountability then moves up. We have, similar to filling a judge's position, we have a commission that reviews it. They're looking at it on a regular basis. They have people that are interested and qualified. When the time comes, they can send those recommendations to the governor, and the governor can ensure that we have a commissioner in that seat.
Well, and that's interesting you say that they're qualified, because when we're looking at these panel members and what I'm seeing when what you're saying is qualified, we should be having experienced management of violent offenders, assisting assessing the public safety risks and the victims' rights representatives. This bill doesn't have any of that.
It does.
It doesn't. It proposes,
as amended, we do have victims' rights.
It proposes a panel of advocates, members of the public, and others who may not—
Have you seen the amended bill, the third reading?
So you added in amendments?
Yes.
There is an interlineated copy under text, third reading version. They've done some changes to the composition of the
Yeah,
commission.
Senator, I'll
It's
read
okay.
it.
I'm pulling it
I'll
up.
read it to you.
I'm already here.
Okay,
Do you want to come back, or
Yeah, you can come back to me. I'm sorry.
Okay.
Apologies.
Senator West?
Thank you, Mr. Chair. I haven't seen the amended bill either. I wanted to focus on a section on page 5 that seems to say each hearing examiner shall, and then it has the qualifications. And the new language would require that each hearing examiner shall hold an undergraduate or advanced degree in only certain specialties, either psychology or psychiatry or social work or education or community organizing. That seems to exclude an awful lot of people who might possibly be good hearing examiners. Why have you eliminated everybody else in the state except people who have undergraduate or advanced degrees in these particular specialties?
well, I think some of the research has suggested that if you want to, once again, professionalize the position, that you need to have certain types of skills. And so those were some of the skills that were recommended. But it also says that you could have community organized or have attained the equivalent of these degrees through training or experience, and have training and experience in the field listed under item 3 of this subparagraph. And item 3 of the subparagraph, let me see, talks about previous employment or law enforcement in the fields of correctional law enforcement.
Where's, maybe I'm
That's
looking.
paragraph 3.
Paragraph 3. Oh, okay. Let me see. Well, it limits to no more than 30% the number of examiners who may have had experience in law enforcement. No, I'm looking at
I know you're looking
lines
at
8 through 11 in the amended bill. So I'm just thinking, lawyers, for example, somebody with a law degree and experience practicing law, I would think would make a pretty good hearing examiner. But this seems to exclude them. They would not be permitted to hold that position under this bill.
And I'm looking at that, Senator. I think I'm open to reconsidering that. I
Okay.
appreciate that.
Those words are my concerns.
No, I got it.
Thank you.
I got it.
All right, well, so Senator Folden, if not, I got a couple questions to you, but go ahead, Senator Folden.
Yes, sir.
Thank you for giving me the chance to look at it, Mr. Chair. So that was kind of where I was going with what I was saying earlier. When you have something as important as a parole commissioner and you have things so heavily weighted towards these social workers, treatment providers, and community organizers, are we really focusing on public safety at that point, or are we focusing on getting more people out?
I think we're doing both. The objective is to do both.
But that's not what's in the language here, because everything on this nominating board or this panel, and as well as
On the nominating board, can I parse out the two?
Sure.
Can I parse out
Please
the two?
do.
On the nominating board, we really did try to gain some balance. So you've got public training, the Police Training and Standards Commission, Public Defender, Maryland State's Attorney, balancing out. 3 service providers from the fields of mental health, substance abuse treatment, vocational and educational training, community organizing, appointed by the governor.
But those people have no experience with violent offenders, with criminal
The
activity.
objective is to get people, once again, who are selecting the commissioners, right?
Understand.
And so we want them to weigh in on who those commissioners should be. And I think if we're looking at commissioners who are focused on, is this person likely to recidivate? Have they gone through? Do they understand from a substance abuse perspective, from a mental health perspective, having those backgrounds, right? And having them think about who that commissioner should be, I think provides value. So that's in that group. You've, because we're talking about often what happens inside of our prisons is education, whether it's higher ed or it is them getting their GED. Superintendent. National Association of Social Workers, which once again,
Yeah,
this is
so
about mine.
I don't want to belabor this. Look,
But we also have the victims' rights advocate, right? So we're just trying to balance, that's all.
But it's not balanced.
Okay.
You have a very heavy-handed part of this is social workers, community organizers, if you will. You have one state's attorney representative, you have one public defender representative, you have one person from the police training commission, and then the other 10 are, I mean, you have one that's at least one Maryland resident who was formerly incarcerated in a state correctional facility. What does that person's expertise, because they were incarcerated, that's their expertise?
It's a lived experience. No different than if I asked the victim to participate. It's a lived experience.
But you had this, the victims were an afterthought.
Senator,
That's why I'm saying, your bill is heavy-handed towards one side over the other. But I appreciate the time, I appreciate the dialogue, but I think this bill's got a lot of work yet, but thank you for the bill.
All right. And as I mentioned, we've heard the senator's bill on the other side. I'm a supporter of the senator's bill. Your chair. He has a similar bill. However, his focus is strictly on the nominating commission. You all voted that out of JPR. Its focus is strictly on the nominating commission to ensure that we get good commissioners, which
But this
bill
isn't that bill.
This is very similar. In that component is very similar. My membership in my commission is a little bit different than his, but not terribly different, but a little bit.
Did I vote for his?
I'm not sure, Senator.
Thank you.
I'm not sure.
Senator James.
Under your bill and focusing more on the hearing examiners, I think that's the area in which the chairman's bill was not focused.
Correct.
Okay, so that's the difference. Would most, if not all, the hearing examiners currently serving be disqualified under your?
No, ma'am.
Okay.
They would continue under the bill. And that was part of the discussion that we had.
No, I think you misunderstood. They might be grandfathered. I'm saying under what you want now, how many of the hearing examiners would have the back?
Many of them may not qualify
Sir,
under.
I want to be
I'm sorry.
super polite, but I think what we have to do, just like we're in a court of law, is I got to ask a question, you got to let me finish. Then you can respond. So I didn't get to finish my question before you respond. I'm trying to figure out whether the hearing examiners that are currently serving, would any of them or most of them meet the new qualifications that you have, that they have one of these narrow, just several different degrees and no other, have some, and/or some experience in long criminology, and/or 30% of them can't have any background in corrections or law enforcement. So how would the current hearing examiners fall under your new requirements?
Sure. So first, as you mentioned, they would be grandfathered. Second, if they came into the system today, many of them would qualify at least for the 30% because they have the experience.
So I think maybe you can get back to me. I'll try to do it myself, but anything you can do. I'd like to know how many of the current hearing examiners that we thought were doing a pretty good job would not meet your newer criteria. I understand they'll be grandfathered, but eventually they'll be out of the system and a wholly new set of requirements. Then I just Googled, not fair to do, but I just Googled if, what would be the essential skills for this kind of role. And to be honest with you, it is much broader than the limited areas you have. And I've got to tell you, I have a Bachelor of Science in Psychology. I am not qualified to be a parole hearing examiner. And that is because this bill does not seem to me to then ask for work experience and experience. You can be a psychiatrist or a psychologist and know nothing about this. So I think, again, the way you've drafted it, I know you're attempting, and this is about improving the process. I think we have missed the mark in some ways. And I don't think an arbitrary 30% even makes sense to me, because it really depends on the nature of the individual before you. And I don't want to predetermine that 30% is an ideal number or a not ideal number. So I'm hoping you'll be open to, suggestions on how we could achieve your goals, but also not undermine the goals that I think Senator Folden and I share, which is that to not sort of prejudge and predetermine who is and is not qualified to do this based on what I've just looked at. So that makes some sense to you? And then as I hear you, your bill, even though it also deals with the nominating commission, I think you've been very respectful. I think what you're saying is if Chairman Smith's bill would be the successful one in that area, that would not, give you a heartburn. You'd be okay with that improvement as well. Is that correct?
Yes.
All right, thank you, Mr. Chair. Thank you.
And if, may
Yes,
I?
go ahead.
The idea of limiting, right now we know that of the 9, I believe 10, at least 8 have come directly through the correction system. And so part of the question is, if we want some diversity of thought in the process of the hearing examiner selection, that we would put some percentage on it. And I think as I've looked at it, that was really kind of, we've taken one mindset and we put that into the hearing examiner process. And just so you know, I actually met with 8 of the 10, I believe it was, and had these discussions with them. It was one of the reasons why we pulled out the idea of last year. We came up with this idea of eliminating hearing examiners. I am convinced that they do a yeoman's job. It took me a minute to sit down and have that conversation with them, and I think that position is critical in what we do. But I did spend a lot of time.
And I appreciate that. And you bring up something that, let me just make another suggestion to you. I feel like, I don't know about the rest of the committee, I feel like I'm unqualified to weigh in on how, if at all, to change them. To me, the better course would be perhaps to study this, and I'd like to really listen to those hearing examiners, because I don't have an appreciation of, I would tell you viewpoint diversity is important. I'm not sure your bill has gotten you to where you want to be, and I don't know that the hearing examiner's background in corrections, you can have a background in corrections and have multiple different viewpoint diversity. So to me, we are in a vacuum here without like a good report that tells us best practices, what are we doing. So I hope you're open to the idea that we may be very interested in the subject you're bringing to us, but maybe want more information, maybe even a study or work group to kind of see what is possible, what is needed, and what do we have currently. All right, thank you, Delegate.
Senator Muse.
Thank you very much. Just one thing I want to elaborate on, but before I say that, I think it's a good bill. I think it's well balanced. You mentioned, and I just want you to elaborate on it, that 80% of them have come through the corrections process.
Yes.
Can you elaborate on that a little bit?
So about 80%, I think it's at least 80%, have come directly through DPSCS. So they've come through the correction system and have become examiners.
Do you see that as an imbalance?
I do see that as an imbalance.
I do too. I do too. Okay, thank you very much. Yeah, I do too.
All right, thank you very much. Is Laura Wilt? Yeah, no, we don't have her on. That's why I was calling. Nope. All right. Is she now? Oh, just came in. All right, she's being admitted now.
All right.
Thank you. Good afternoon, Ms. Wilt. The floor is yours.
Yes, good afternoon, Senators. My name is Laura Wild. I'm senior attorney in Baltimore for the Maryland Crime Victims Resource Center. And I am here testifying opposing House Bill 16. The most important factor when looking at the issue of a parole bill should be how critically serious the work of the commission is. The Parole Commission's decisions are life and death. The data proves that parole releases in fact result in many additional victims. A 2021 study by the U.S. Bureau of Justice Statistics tracked over 409,000 prisoners released from 24 states. there were 77% of the violent offenders were rearrested within 10 years. 53% had to be returned to prison. Darnell Hawkins was paroled by our Maryland Parole Commission in the fall of 2025. Within just 3 months of his release, he murdered 3 people. Brittany Ray, Harold Finch, and Brianna May Weishar, all of Clear Spring, are gone as a direct result of a parole commission's decision. On behalf of crime victims and your neighbors, we ask you not to take lightly the importance of the qualifications of this parole commission. House Bill 16, as amended, gives the governor complete power of appointment, removes the secretary and the Senate approval. Page 3, lines 13 to 17, seem to make this lifetime appointments. There's no further review, no further approval, and that seems highly improper. Finally, the last minute amendments added on page 5 recklessly, as you pointed out in your discussion, watered down the qualifications of those serving on the Parole Commission. 70% of hearing examiners are to have no experience in law enforcement or correctional services. As you point out, this flies in the face of common sense and legitimacy. Years of experience are required to make these very serious decisions. I believe House Bill 16 will result in violent offenders being released by persons relying on little more than naive optimism. For all
Thank you very much.
Yes. On behalf of victims, an unfavorable report on House Bill 16.
All right, we have a question for you, Senator James.
Yes, and thank you very much for participating, because it's very important that we hear from victims groups. In Annapolis, we often hear from everybody but the victims groups. So I'm so glad you would take a moment. You know, you can tell I'm hesitating myself about the bill as it is drafted, but it brings up a point, and we can talk about this offline or later, but if you're right that, and I'm sure your data is probably pretty accurate, that 70% or whatever it was of people that were released between a certain period have reoffended, it almost begs the question of, is the current hearing examiners strict enough about parole in the sense of letting people out that, you know, habitually reoffend in overwhelming numbers? So if you have a brief response or comment to that, because I don't want to derail this, but since the bill is about the qualities of hearing examiners, it sounds to me like even our current hearing examiners, we're struggling to make good decisions about public safety and welfare when we release people that habitually and overwhelmingly reoffend.
That was a nationwide Department of Justice research study. Right. So I think you're smart. We have to consider these. People don't want to say the ugly truth. When parole is making a decision, you have to consider they've had multiple. The state's attorney's office estimated 16 possible reviews by a court, appellate court, you know, a second look, a JUBRA, all those hearings. Many, many hearings represented by counsel have denied the release. That's how important these parole employees are and the decisions.
No, thank you very much.
Thank you.
If I may ask, this report that you're talking about, when was that published?
It's a 2021 Department of Justice Bureau of Justice Statistics, and it was a 2021 recidivism study.
And so you mentioned in your testimony, I'm assuming a case that happened here in Maryland?
Yes.
In your district?
And yes, it just happened very recently. And we looked into it quickly, but there were 3 people murdered in Washington County, and the individual charged was with 2 others recently released from prison, and now all charged with those first-degree murders.
So just out of curiosity, that's how are you aware of how many cases that people who've been released by the commission have been involved in some sort of recidivism?
I personally don't know a Maryland statistic. And is Maryland, I know that's something that we've suggested on a number of bills, don't just count the number of hearings we're having, count the recidivism. We've added that in our suggestions for multiple bills. Look at the recidivism rates for those who are released at 1 year, 3 years, 5, 10. Let's look at the data, but nobody wants to collect that data. I feel like some of us do, but not everybody.
All right, thank you, Senator West.
Thank you to this witness for pointing out a provision of the bill that I had missed, which removes the advice and consent of the Senate for the appointment of these nominees. I'd missed that before. Do you know on what's the rationale for removing from the Senate the power to just make a final decision as to whether the governor has appointed the proper people?
I mean, you can see the commission or the panel is made up of every single person there is either appointed by their job description, like appointed through their position, or to the panel directly by the governor. It is completely a one-sided process.
Okay, thank you. Thanks for pointing that out. I had missed that when I read the bill.
Senator Meese.
Thank you very much. I missed it if you said it. Do you have the recidivism rate for the state of Maryland?
Right, I don't have that. That's why
sorry.
I hope we start collecting it.
Okay, you heard them say that there were, out of the 10, 8 who have gone through the correction system. Do you consider that balanced?
I think you have to look at more than what their job was. I think you have to have people who worked in corrections, but maybe they worked in corrections and have a social work degree. The way the bill is drafted, it says if you've worked in correctional services or law enforcement, I think is the language, you can only make up 30%. So there's a lot that can be kind of worked here. I'm not opposed to psychology, social work, all those degrees are important, but it excludes people that use that knowledge in the area of law enforcement or corrections. So it's way too exclusive.
Thank you.
Thank you.
And seeing that there are no further questions, that will end the hearing on House Bill 16. Thank you all very much. Next, we're going to hear House Bill 1166, Delegate Blakovich-Carr. If you have witnesses, they can come. Do you have witnesses?
No witnesses.
All right.
All right, so good afternoon. For the record, I'm Delegate Julie Plakovich-Carr, here to present House Bill 1166. As the committee knows, most vehicles registered in the state of Maryland are required to have both a front and rear license plate, and we are among 31 states plus DC that require 2 plates. Unfortunately, some Maryland motorists are not complying with this state law. Last year, there was about 4,000 citations that were issued in Maryland for failure to display a front plate. And there are good reasons to be concerned about this seemingly minor infraction. Front license plates serve an important public safety function, as pointed out in the informational testimony from the Maryland State Police. They wrote, quote, "From a public safety perspective, the additional front license plate plays a pivotal role for investigators. Officers and civilian witnesses across the state can easily identify and report vehicles suspected of involvement in criminal activities, missing person cases, hit and run collisions, and other motor vehicle related investigations," end quote. Front license plates are also important for our state's ability to collect toll revenues. The Maryland Transportation Authority issued a report a few months ago that was looking at data for all of 2024, and they found that there were 6.6 million toll transactions in our state that relied on images of front license plates in order to be able to bill those vehicles for their tolls. Without those front plates, the state would have lost out on $35 million in toll revenue in 2024. So I would say that for every vehicle in Maryland that's operating on our roads and is breaking the law and does not display a front license plate, there are real costs to our state in terms of foregone toll revenues and in terms of missed opportunities to help our law enforcement agencies. So I hope we can all agree that it's in the state's best interest to ensure that motorists are complying with this law. As I see it, we have 2 options to get better compliance. And I'll say I've looked around the country to see what other states are doing. One option would be more police enforcement, just have police issue more tickets. I'll say I'm not a fan of that for several reasons. I've guessed that other members in this room feel similarly and wouldn't want to go that route. Second option, which this bill takes, is to make it easier for drivers to comply with the existing law by ensuring that when someone buys a new vehicle, that the vehicle already has the front license plate mounting bracket installed on the vehicle. So that way when their permanent plates come in from the MVA, they have somewhere to attach that front license plate to. And this is, in fact, a law that California adopted more than 20 years ago, and it's been working well there. So that's all that this bill does. It just says that automobile dealers, when they are selling a new vehicle in Maryland, for a vehicle that's going to be registered in the state of Maryland, that the front plate bracket is installed at the time of sale. And I'll note that many dealers are already doing this. That was my experience this last fall when I purchased a new vehicle in Rockville. I think for these dealers, this is good customer service. That's just making it easy for their customers to be able to comply with the state law. And this bill changes nothing at all for the dealers that are already installing those front plate brackets. So this bill is about, I would guess, the minority of dealers who are allowing their customers to drive off of their lot while committing a misdemeanor. And it's not just the vehicle owner who's breaking current law. As the MVA recently reminded auto dealers, they also have obligations under state law and in fact could be considered a principal or accessory if a customer refuses a front license plate bracket. So this bill really is about helping dealers to comply with this existing law and existing requirements. So in conclusion, I think this bill is a simple way to get more vehicle owners into compliance with state law, to make sure that our state's receiving our toll revenues, and to help our law enforcement to solve crimes. And it's a bill that's supported by our law enforcement associations, and I'd say the amendments that we adopted in the House reflected the technical amendments from the MVA. Thank you for your consideration.
Thank you. Yes, Senator.
Thank you, sir. Thank you, Mr. Chair. Thank you, Delegate, for bringing the bill. So given that MVA doesn't have an independent enforcement agency, can you tell me why the purpose with the intent of the monthly dealer reports to the MVA is going to serve? And how is the MVA going to use this information?
Yep, happy to walk through that part of it. So the bill is amended in the House no longer has monthly reports coming from the dealers. Instead, it's when the dealers are processing the registration paperwork for a vehicle that they've sold, assuming that they've done the registration, that if the customer has refused to have the mounting point installed on the vehicle, the customer could choose to sign a document that the dealer would send along with the registration paperwork to the MVA. What MVA has said that what they would do with that information is there is a technology system that apparently allows the MVA, it exists now, MVA and law enforcement agencies to communicate, and they would be able to put a flag on that vehicle's record. So if in the future a police officer pulled over that vehicle, the flag would just say, check to see if there's a front plate on there. If the customer has a front plate, that's the end of it. The flag gets cleared, nothing happens. But if the vehicle did not have a front plate, as is required under state law, the officer would have the option, as they do right now, to issue a citation.
Okay, thank you, Delegate.
Senator Folden.
Thank you, Mr. Chair. Thank you for bringing the bill, Delegate. I just wanted to ask, you're saying that you made the comment that if they're letting them walk or drive off the lot, they're knowing that they're in violation of a misdemeanor. How many temporary tags does the state of Maryland issue?
So I'll say it's not about the temporary tags. What MVA has previously communicated to the Automobile Dealers Association is they have an obligation to put these brackets on the vehicle.
I understand, but the state of Maryland issues how many temporary tags on a vehicle?
Well, any new vehicle, like if you don't get your permanent tags immediately. And again, this bill's not about the tags, it's about the mounting point. Because I fully understand, when a new car drives off the lot, it does not have a front plate because it doesn't have the permanent, but it needs to have the bracket.
So it's not in violation. They're not in violation of the law at that time. What this is doing, this is creating a new misdemeanor is what you're wanting to have happen, right?
No, there are no penalties under this bill. No.
So if they refuse to sign the document that you're saying that you would like to see on top of every other document that has to be signed when you buy a vehicle, if they refuse to sign this document, does it terminate the contract? Does it void it? Can they not take delivery on the vehicle?
No, none of those things happen. There's no penalties under this.
So they can just refuse to sign it and that would be sent to the MVA as a refusal?
Actually, the bill doesn't even require the dealer to document that at that point. But under current law, right now, the MVA could go after that dealer for not installing the bracket, as well as go after the customer for not having the bracket.
So this is always a big thing for me when we have, government big government trying to get involved in the very finer details of things. And now we're wanting to put a flag on a vehicle that may not have its front tag on because they chose not to have it installed by the dealer at the time. So I just, there's no penalty on this, but we're flagging them in a system. I'm just trying to understand out loud what we're doing here. And that if they get pulled over, there's going to be a flag that says they need to check for the front plate.
That's all right, yes.
But they can be pulled over for not having the front plate on already. So the flag would kind of be.
They could, yes. Police right now could pull vehicles over as a primary offense for
I'm
failing
surprised.
to have a front plate.
Look, you guys love these cameras. I'm surprised y'all haven't come up with some camera idea to just start citing everybody without a front plate. Because, my heavens. Okay, thank you for the bill. I appreciate it.
Senator James.
Delegate, thank you. I think this is the first time I've gotten to see you. Because I'm not familiar with this area, firstly, are you saying that cars sold in Maryland, some of them do not have on, I guess it's the bumper, fender, the bracketed infrastructure in the front and back, or just the front?
We're talking specifically about the front.
But how does that roll out? And how many, I've never seen that at all, and I've been on the planet a little while, and I've never met anybody. So I'm trying to get a sense of what percentage of cars is in yours, that this is what this bill's about, aren't being sold with that bracketed hardware for the front license plate.
Right, and I don't think we have good data on that. I'll say, just because coincidentally I went through this experience in the fall, and it's like, you know, the dealer didn't ask us, do we want the front mount point? They just did it because we knew we would legally need it. I started paying attention to just what was going on with other dealerships, and you know, I live in an area where I think probably every car brand that's sold in Maryland is in my district, and I've been looking at their lots. A lot of them will just preemptively put the mount points on the cars even before they're sold.
Yeah, I've never bought one without it.
Right, and with speaking with the dealers, apparently that is not always the case, and for good reason. In some parts of Maryland where you're closer to borders with other states, you know, they know that some percentage of their customers are actually buying from another state that doesn't, say Pennsylvania or wherever, that doesn't require a front plate, and so they don't preemptively put the mount on, and that's fine, and that's still legal under this bill, and there's no issues with that. But anecdotally, I have just been seeing more and more vehicles that are driving around. I've noticed more vehicles with the license plate, say, sitting on the front dashboard because they don't, say their Tesla or some other vehicle doesn't have the mount point on it. It wasn't installed.
Yeah, I think the reason I'm asking is that before we ask government to come in and involve itself in something where government already is involved, this is not you're not legally allowed to do this. You're now enlisting all the private businesses that sell cars. I'd like to get a sense of just how many are not doing this, so I can even understand what your bill might accomplish. Secondly, my second question would be more about where else has this happened, this kind of law, and I'd like to know what the nature of the dealers were in there. You know, was it 10% that didn't provide it, 15%? And then what was the resulting change in behavior, which is what you're looking for, and compliance, particularly since there's no penalty, there's no obligation. So give me any information about that.
Right. One other state, to my knowledge, has adopted a law like this. It's California. Their law's been in place for more than 20 years. I have looked to see if there is data about what has happened while the law has been in effect, and there simply is not any. The dealers are going to come up here and say it hasn't worked. I don't know what information source they're basing that off of, because literally the data does not appear to exist. But anecdotally, from reading news reports, from reading Reddit comments, other comments online, the dealers do appear to be complying with state law in California and doing it pretty strictly.
And the reason I bring this up, and I do appreciate what you're trying to get at, we've actually have another bill that my staff really educated me on because I was resistant that MVA had come in here and SHA to ask us to make sure we allowed for capturing some tolling on trailers that were not necessarily had a front license plate, or that license plate was obstructed. And some of our problem is our surrounding states have, in the last, let's say 20, 25 years, become more popular to maybe not require a front license plate. So I am aware of and understand what you're getting at. My issue is, I think bills like this need to come to us with some data that suggests that this, before we get everybody involved, that this is a good solution to the problem. And it seems to me the way to have done that is maybe do a work group, get the dealers involved, have a study through this bill, not this bill, see what the percentage is, see what the achievable goal might be, and whether this is even an effective way to do this, rather than to talk anecdotally. We all have stories. And so I guess what you're saying is you don't have, that has not happened yet, and you don't have data yourself to sort of support whether this is the best way to proceed with the issue. Is that?
Well, I'll say I am also a scientist by background, as you are, so I
I'm a
totally
lawyer,
understand.
but a Bachelor of Science degree, and that is where I
Right.
emphasize most of my thinking.
And I very much appreciate that. And so, yes, it does pay me to say that all we have is anecdotal information at this point.
Right.
There really, it's not just that I don't have the data. I don't think anyone has this data. I don't think there appears to be any way to get at the data is what the issue is. Besides, we know the number of citations that have been issued in the state.
Right. And that is where we ought to begin and get the stakeholders involved. And hopefully we can work on that together. So it sounds like we both want the data.
I would agree with that.
Thank you, Mr. Chairman.
Senator West.
Thank you, Mr. Chair. Thank you for bringing this bill, Delegate. Currently, there are certain offenses where on the basis of which police can stop someone traveling on the road. And we've had legislation proposed in this committee for the last couple of years suggesting that some of those offenses, like littering, should be taken off the books so police can't stop cars for littering. Well, let me ask you about the failure to have license plates on the front of the car. Is that the kind of an offense for which currently police can stop a motor vehicle?
It is.
Okay. That being the case, I guess my question is, why do we need this bill? Why can't we just rely on the police to stop the vehicles on the roads that aren't bearing license plates where they should be bearing them? And it sounds like it's a significant fine, $500.
$70 if prepaid.
And $70 to prepay. Well, even so, $70. I'd rather not have to prepay $70. I'd rather have my license plates from the get-go. So why can't we just rely on the police to do their job? Why do we need this bill?
Yeah, and I think that's a fair question. And I mean, this committee knows much better than I do, since I serve on the Ways and Means Committee, about the debate that's been happening for a number of years about police stops, and do we want more or less traffic enforcement stops? And I think this falls into that broader debate too. I mean, police clearly are ticketing folks for this, but I would hazard that 4,000 citations last year is probably not representative of what the full scope of the problem is. And I would guess that many of our law enforcement agencies would say that they, have a lot of other demands on their time and resources in terms of what they're going after.
Okay. I will also say that I've bought a lot of cars over the course of my many years of existence since I was 16 years old. And I can't recall running into a problem. I just assume when I drive my new car off the lot that my license plates have been put where they're supposed to be. And if mounting plates are needed, the mounting plates are on the car.
And I think you're exactly right, and I don't mean to cut you off, but
Yeah, no, go ahead.
Yeah, I think you're exactly right. That is what most dealers are doing. And certainly when I started looking around and driving around and looking at the dealerships in my district, most are doing that. Some are not. Some do not put mounting brackets on any vehicle on their lot. And even when they are selling the vehicle, they are not installing the mounting bracket.
And they literally let people drive off without license plates where they're supposed to be, thus subjecting the drivers, who may not know any better, to a $70 fine if it's prepaid or a $500 fine if it's not prepaid?
That's right.
Huh, okay, thanks.
In fairness, the senator, when he started writing.
Leave him alone. Leave him alone. Leave him alone. All right, thank you very much. We have two people who have signed up in opposition, Mr. Kitzmiller and Mr. Johansson.
Good afternoon, Mr. Chair, members of the committee. My name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchised new car and truck dealers and our 20,000 employees across Maryland here today in opposition to House Bill 1166. I'm going to go off script here a little bit. Let me be clear. All 300 of my members install front license plate brackets on a vast majority of the vehicles. It's not that some dealers just don't do it and some do. All of them, the vast majority of vehicles, the front license plate bracket is installed. So I wanted to correct that, number one. Number two, there's been no data presented demonstrating that front license plate violations are increasing in Maryland. And without evidence of a growing compliance problem, it's difficult to justify these requirements. And as the sponsor indicated, California is the only state in the country that has a similar law. They've had it for 20 years. My information in talking to the California Dealers Association is it has not increased compliance at all. They have asked periodically over the last 20 years for data showing that it's increased compliance. It has not. In addition, California's law does not have this recording requirement, which in our opinion is a significant problem. And getting to Senator Fulton's question, again, vast majority of the vehicles that leave have front license plate brackets on them. Most of them, if we do the plate installation, we do that as well. Many vehicles leave on temp tags, and we now ship the tags or mail the tags to the customer. So we have no idea at that point. So at the end of the day, this bill creates unnecessary paperwork that complicates the sale process, and it's going to create customer relations problems. Customers don't expect to come into the dealership to sign documents that may ultimately share with law enforcement, particularly when they haven't violated the law at that point. So in our opinion, this bill creates paperwork and customer relations problems without solving the problem, and it hasn't been demonstrated that we have a problem to begin with. So for that, we'd ask for an unfavorable report.
Senator Fulton.
I know my good friend across the aisle here is smiling because that's a very interesting point, that we're sending notification to the government of a potential violation. So to flag for police enforcement. So I think that that's something she's still smiling, so it must be okay. Unless it's a really bad smile, then it's a problem. I don't know yet. I haven't learned yet. But that was a great point, and thank you for coming today. But I wanted to ask you one thing. I believe the sponsor said that 31 states, I guess, require 2 tags.
I believe that's correct, yes.
Okay. Is there any state that immediately surrounds Maryland that only has 1 tag?
Delaware, Pennsylvania, and I know for sure, and I believe West Virginia as well, but I know Delaware and Pennsylvania for sure.
Okay.
Require 1.
And not that anybody's like flocking to Maryland to buy vehicles with the current, fee structures we do. However, if they did, because money wasn't an option, wasn't an issue, Maryland dealers could sell to those out-of-state locations, right, that don't require a front tag.
We do that every day, yes.
And so a lot of new vehicles, I know all new vehicles that I've seen come in, they always have the tag bracket. It can be in the back in case it is an in-state or a 2-tag state. But if it's not, there's no reason to put holes in the body of the vehicle as well, right?
That is correct, and I was not aware of this before we had a conversation on this bill. My dealers on the Eastern Shore say Delaware customers, it's a deal breaker if the car has a front license plate bracket on it for whatever reason.
I don't wait to put them on,
but
they'll also wait to put them on
Correct.
to see if it's a Maryland state. They don't know where the vehicle's going, is my point.
Correct.
It can be sold anywhere. I mean, the age of the internet can be sold to California. And
We sell to all 50 states now.
Right. All right. Thank you. I appreciate it.
Seeing that there are no more questions, thank you very much. Mr. Johansson, is he here?
I don't believe that he is.
Twice, all right. That will end the hearing on House Bill 1166. Next, we're going to go to House Bill 844, Delegate Griffith.
All right, thank you, Vice Chair Hayes, members of the committee. For the record, my name is Delegate Mike Griffith, and I'm requesting a favorable report on House Bill 844, Motor Vehicle Registration Fee Exemption for Unemployable Disabled Veterans. So as the committee knows, right now, if you're a disabled veteran with 100% service-connected disability, you get 2 vehicles where you're exempt paying the vehicle registration fees. But there's a subset of veterans that receive 100% disability benefit, but don't have the 100% designation. They're called unemployable veterans. It's a subset that's kind of stuck in between 2 worlds. And because of this, these 4,000 Marylanders are, because of that technicality at the federal level, these 4,000 Marylanders are unable to get the benefit of the vehicle registration fee exemption that their counterparts with the actual 100% designation receive. So what this bill seeks to do is close that loophole and extend that same benefit that other 100% disabled veterans get. Now, the General Assembly, including the Senate, recognized this as a problem because I offered a bill 3 years ago to close this loophole for DNR licenses, and we successfully did this. This bill was hung up in the House for the last 3 years because of the fiscal note tied to it. So we did a couple of things to try to shrink the fiscal note, primarily with this bill. households are only able to get one vehicle registration exemption versus the two for 100% disabled. We would prefer to have the two, but for the purposes of our physical situation and making sure we are taking care of these disabled veterans, we are happy to move forward with just one. And I think we solved that physical note both in the legislation and in the budget. This bill is supported by the House Veterans Caucus as well as the Maryland Military Coalition. And again, we've already acknowledged this is an issue with DNR licenses, and we're just trying to, again, close that loophole for these unemployable disabled veterans. And with that, I would urge a favorable report.
Thank you very much, Senator James.
I just want to say, Delegate, this is a Harford County delegate, and I think this is the first time I've seen you in the committee, and it's so great. I also just want to compliment you on a really good bill that, even 3 years, but you kept at it and developed consensus and compromise, and I just think it's a wonderful bill, and I hope we can pass it for you.
Thank you. I appreciate it very much.
Senator McKay.
Great bill. My question is, have you had any conversation with the Motor Vehicle Administration anticipating any kind of administrative challenges, verifying?
We had conversations 3 years ago, and there'd be no issues. All they would do is just, this language would just capture, add to 100% military service and disability. They would add the unemployable status to that. And again, it's just a technicality at the federal level that's not contemplated in our language. So it's just an oversight that we're just trying to fix.
Thank you for your answer, sir.
Thank you very much. Seeing no other questions, I believe we have one other person testifying favorable. And I apologize if I mispronounced your name. Was it Buck Naked or Naked? All right, going once, going twice. All right. House Bill. That's a joke.
All right.
No.
No. All right, I'm sorry.
So I assume that means the chair plans to move favorable on my bill. Thank you.
Oh my God.
And again, just in case the chair didn't hear that, hopefully that means the chair plans to move favorable on my bill. Thank you very much.
I appreciate it. Oh my goodness. All right, that's it for it. That's the last one, I promise. All right. Whew. All right. Which bill are we on next? Who's next? Thanks.
Skipped over.
Is okay, and then I know Holmberg is here, and then come on up. Do you want to come? Yeah, come on up. Yeah, and then we'll go with Baylor, and then Hornberger's over there, and we'll go through.
Thank you. Thank you, Mr. Chair, honorable members of the committee. For the record, I'm Delegate Matthew J. Schindler, and I'm here to testify in support of House Bill 22. House Bill 22 ensures that when an individual is released from incarceration, they leave with something fundamental to reentry: a valid Maryland Motor Vehicle Administration issued ID or driver's license. Without state-issued identification, returning citizens are effectively locked out of society. They cannot apply for jobs, secure housing, access health care, enroll in education or workforce training programs, or even obtain basic social services. We release individuals back into our communities and expect them to become stable, productive residents, yet we deny them the most important document required to do so. That is not accountability, that is a setup for failure. I believe that this bill is a common sense investment in outcomes that we want, which are fewer repeat offenses, stronger workforce participation, and safer communities. This bill is about removing needless barriers at the very moment we're asking people to succeed. This bill can be accomplished with existing MOUs, and it carries no fiscal note. This was also crafted with the support of DSCPS and had no opposition. And with that, I would say Maryland has long prided itself on smart, evidence-based policies. HB 22 aligns with that tradition, and if we're serious about reentry, rehabilitation, and public safety, then we must ensure people leave incarceration with the basic tools that they need to succeed. With that, I favorably ask for a favorable report on HB 22.
All right, thank you very much, Delegate Schindler. Questions from the committee? We have Senator James.
I just think it's a great bill. And I feel like it's, I had no idea that we hadn't thought of it before, because it looks to me like corrections already does provide an identification, right? But I don't know what that identification is, and I don't know how well you can parlay that in the world, but we certainly know, I think what you're doing is making sure it's, it's driver's license or birth certificate or both or something like that, of which the state is used to making those documents easily, right? So we're just making a smarter decision. And I take it corrections, you work with them and they're supportive, and MVA is supportive?
Absolutely. Thank you, Senator. And yes, we worked with DSCPS on this when we crafted this. They have MOUs, as you said, with the MVA. Right now, they send people out with a secondary or a prison ID.
Yeah.
But many people are leaving without an actual, state-recognized identification.
Yeah, no, I think it's a great idea. I really think it is. Thank you, Delegate.
Thank you.
So, thank you for the bill, Delegate. That just prompted me to think of something, because of course my first thought goes to, all the scrutiny we're doing on multiple tiers of identification for voters and all these other things. But if someone isn't here legally and they're incarcerated, what would they be provided with?
Well, in that case, I can't imagine they'd be able to provide them with a state identification then.
Well, but it doesn't.
So this would.
Does it say anything? Am I missing the point of this here? Am I missing something? Like, it says that they would be in possession of one of those things.
Yeah, so if someone wasn't born, so the prerequisites to getting a state identification, of course, are birth certificate, social security card. There's prescriptive language in the bill about trying to obtain those prerequisite documents.
Wasn't always that way. We were giving out driver's licenses to anybody like they were candy.
Gotcha. Well, yeah, in this bill, it prescribes the process of getting those prerequisite documents. Of course, if someone wasn't born here, they wouldn't have a valid birth certificate.
So we wouldn't be just required.
Correct.
I'm just going to have.
Correct.
Okay. All right. Thank you.
Thank you, Senator.
All right, further questions from the committee? All right.
Thank you.
Great bill. Thank you very much. All right. And yeah, Senator Fulton, I mean, look, we've been, under the O'Malley administration, we did expand the eligibility for driver's licenses to, as a matter of public policy and public safety. You want people to be, qualified to drive on the road. But yeah, to your point.
But I think did we take care of a lot of that when we did the Real ID stuff?
Well, that's an evolving thing right now, because to be Real ID compliant. Right. All right. With that, that'll conclude the hearing for House Bill 22. Delegate Odom, so I'm sorry, you were behind the podium. We didn't see you before. You've been here for a very long time. Would you like to be next, sir? Come on up, please. That's an invitation. Yes. And apologies for delay. I didn't see you behind the podium there. So welcome to the Judicial Proceedings Committee.
All right. Thank you. And greetings to you, Chairman Smith, and to the esteemed members of the Judicial Proceedings Committee. For the record, I'll introduce myself, Delegate Darrell Odom, and I'm here to give testimony with respect to House Bill 1567 and ask for a favorable report upon my completion. As Maryland continues to expand multimodal transportation options, it is increasingly important that our laws clearly define safe behavior for all users of shared roads, trails, and others. House Bill 1567 prioritizes pedestrian safety by requiring riders of bicycles, motor scooters, and electric personal assisted mobility devices to simply issue an audible warning when passing pedestrians in shared spaces for bikes and foot traffic. Under current law, you should know that there is no requirement to provide any warning if you're riding a bicycle and you come across pedestrians and you wish to pass. So there's no such requirement to date that you do so. This bill strikes an important balance in enforcement by establishing violations as a secondary offense. So it's not a punitive thing that we're seeking. We just simply want to make it more safe for pedestrians and bicycles that share pathways or paths so they can exercise their freedom, safely. Together, these provisions aim to promote predictable, courteous behavior on shared transportation infrastructure and reduce the risk of pedestrian injuries and help align Maryland's laws with the realities of modern micro-mobility. So currently, in adopting this measure, Maryland would be catching up with other states, such as Michigan, Massachusetts, Virginia, Minnesota, and Colorado. So we'd be among those groups that actually have audible warnings. And again, there's no desire to act primarily in a punitive nature. It's a secondary offense so that police would not be able to stop a bicyclist or someone that's passing pedestrians unless it's a secondary violation that they're pointing out to them. So it's not intended to change any of the behaviors of the current bicyclists. I've gotten feedback from a number of bicycle organizations within the state. I should point out, I shouldn't jump and share what was unfavorable about it, but what was found to be unfavorable among those groups was the intent that was initially put into the bill that we've removed since having the conversations about actually requiring a 3-foot buffer. There was a lot of angst in terms of bicyclists indicating and stressing that that would be impractical to enforce. So in sharing that conversation with them, we've actually extracted that language. Also had a note from the Maryland Department of Transportation that shared that same concern that the enforcement might be a challenge if we try to enforce that 3-foot buffer, so we removed that. The only other point with some of the bicycle community, as I shared with them, was that they had concerns about other e-motos and vehicles that share the roads that are not actually classified as bicycles. And so I simply shared with them that I would be happy to express the concerns there in a future bill to concern those matters that they have. So with that, I just simply seek the favorable consideration from the committee in HB 1567.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this bill. Can you share a little bit more about the 3-foot passage part? Being somebody from a elderly community on sidewalks, I tend to believe putting that back in your bill is significant. We do a lot of things in Maryland General Assembly that may or may not be easily, and I tend to believe people on bicycles, if anything, should have the courtesy of giving pedestrians at least a 3-foot buffer. So can you share a little bit more about that compromise? I understand you're trying to make a bill better and get everybody involved, but like I said, for somebody who represents a lot of senior citizens that deal with tremendous amount of bicyclists who already share the road, I tend to believe they take the road. Now they want to take the sidewalks, and anyhow, I'm seeking a therapist on my my issues with them. But that being the case, sir, just maybe share a little bit more of your dialogue why you conceded to that, sir.
Certainly. Some of the avid bicyclists pointed out that a number of sidewalks and areas where they share the passageway with pedestrians may not have the necessary area to where you can actually keep that separation as you pass a pedestrian. So taking that in consideration and understanding that could certainly possibly be the case, it would put, it would complicate the matter if there was a situation where they were cited for not allowing that passage, and then it would be a question in terms of, okay, well, was there even 3 feet available to allow that? So taking that in consideration, we removed that from that. And as I stated, that the Maryland Department of Transportation also had a concern in terms of being enforceable with the 3-foot buffer.
Yeah, well, we've stated that they don't have the enforceable part. That would be law enforcement. But thank you very much. I appreciate you working with somebody on it. I'd love to put it back in there, sir.
Okay.
But thank you, sir.
Delegate, I actually learned the hard way. I put in a bill this year brought to me by chiefs of police concerning electrical bicycles because there have been other safety issues that have been coming up over the years. And I learned that there may be 1, 2, 3 potential groups that are in regulation or informally been created. I think MDOT has just recently created one. I think my bill helped them create it and put my chief on this board. But what I learned is that some of these issues that are coming from all over the place are sometimes better filtered through these several boards that are trying to constantly come to the General Assembly when it's time to maybe comprehensively talk about another aspect of safety, because especially with the advent of the electric bicycles, right now I think they're capped at a speed of, I don't know, 15 to 28 miles. All new to me. So I don't know if you'd be open to having the bill adjusted in that way, and or because of the difficulty in enforcement, I think as long as we have this on the books, then it could be in a case of an accident, would be obviously evidence of negligence, just like if you didn't use your turn signal when you're driving. Most people don't get pulled over, but if you didn't use it, it certainly would be evidence that you may have been negligent in the way you were operating your vehicle. So I don't know if either of those ideas are appealing to you, but one is that I'm not sure about the fine because I don't see that law enforcement, I think it'd be 1,000,000 to 1 that a police officer would be able to witness it. But I also think you're bringing up one of a dozen safety issues that I have learned myself about with particularly, not just bicycles. I know they asked you to put the bicycles in. It wasn't your original bill. But with electric vehicles, electric bikes, we're trying to constantly think about how to make them safe. Were you aware, as I indicated you, that there was a safety board within MDOT about electrical bikes? Maybe you knew and I didn't.
No, I can't take claim that I was aware of that.
Yeah.
I'm learning now that there was a board there.
And I throw it out to you because you may, and I, but both may additionally have additional interest in this area, and maybe we can work together. But now that I know this board exists, I think I'm going to consult them going forward just to make sure that, we can all get on the same page. But thank you very much for the bill. I appreciate it.
I appreciate that comment.
Thank you.
And I intend to, having learned that now in the future.
I'll send it over to you because I learned myself. There's 3 things, but particularly MDOT has a newly created board about this.
Thank you
All right,
very
thank you, Mr. Chairman.
Thank you very much and good afternoon. I'm looking at page 3 of your legislation, and I want to talk about lines 6 through 11, where it says that a police officer may enforce this section only as a secondary action. Secondary action meaning what?
Okay, I'm going to try to look at it as a law enforcement officer. If there is no reason for, just like a seatbelt, I think, and I'm using this comparison, I hope it satisfies your question. I don't think, well, no, that's incorrect. You can be pulled over for not wearing your seatbelt.
So we're talking kind of similar to primary and secondary offenses in the traffic context?
Yes.
All right,
So there's no, if the officer has nothing to cite a bicyclist with, then they cannot just cite them for not giving the vocal alarm.
10-year-old child is riding their bike. They don't hit a bell to let you know that they're passing. Officer sees them, that child maybe runs into something. Under this, now the police officer can come in and cite them for and give them a ticket for $25?
I would assume, because if they have an accident and run into somebody and somebody's injured, then if an officer comes and investigates that, then, I can't speak precisely what the outcome would be, but I would presume that the officer deemed that there wasn't a proper warning given.
Is that your intent? I mean, because I guess when I initially look at, oh no, we ask, is that your intent, to get these children?
Not really.
Okay, so that's what I'm trying to
I
understand.
didn't have children, bicyclists in mind. I'm thinking in terms of where we have a high impact area, and I mean, and it's increasing all over. I know the state, I believe. I know in Prince George's County, we've got a number of designated lanes, and we got a number of designated areas in our parks that the riders share, but I never intended to have this bill applied to someone underage.
And unfortunately, that's what, I believe that's what would happen though, because it doesn't distinguish who the rider is. It's just if a person operating a bicycle. So I just wanted to point that out. I wanted to understand your intent, so thank you.
Okay, and I appreciate you pointing that out, and that's something that maybe needs to be specified, because I don't in any way intend to have a child responsible.
Yes, thank you. You're a fairly new delegate, right? When did you come in? This year?
I came in the day before the session began.
This is the first time before our committee.
This is the absolute first time being on the Senate side to present anything to.
Delegate Odom used to be our police chief.
Fire chief.
Prince George's
Senator,
County.
sorry for the correction. Fire.
Yeah, I'm sorry, fire chief. In Prince George's County, we worked together for a long time. So I just want to say welcome. You did a good job.
Thank you, sir.
Thank you.
Thank you.
Okay. Thank you for that. That's great. Well, thanks, Delegate. Seeing no further questions, that will conclude the hearing for House Bill 1567. Thank you very much. Good to see you. All right, we're going to go on to Delegate Baylor, and then we're going to move on to Embry, and then Hornberg, and then
Good afternoon, Mr. Chair, members of the greatest committee in the General Assembly. For the record, I am Delegate Dylan Baylor from District 30A, testifying in support of House Bill 938. At its root, this bill is about pedestrian safety and ensuring that those pedestrians in our roadways are protected. I've been a delegate for a little over a year now, and I think one of the most notable things that I have heard and continue to hear from constituents is a desire and a need to protect pedestrians in our roadways. Over the course of the summer and even over the course of the past 2 weeks in my district, we've had some terrible instances of pedestrians being hit by vehicles in our roadways. So that kind of started conversations at the local level to try and figure out ways, whether it's infrastructure improvements or whatever it may be, to put forth better pedestrian safety. At the same time, concurrently to those conversations, there were also similar conversations happening in other local jurisdictions and related to automated enforcement for crosswalks. And that is kind of what led to the bill before you here today. I will start, it's kind of an interesting bill to testify on because there were 3 separate bills in the House of Delegates from Montgomery, from Prince George's, and from Anne Arundel County, all very similar, but all a little different. So the decision of the House was to amend all 3 of those bills into one bill. So I am here testifying on behalf of those 2 other jurisdictions. There are a few amendments to the bill that I want to touch on more specifically to kind of talk about where the bill is now. But again, high level, what this bill would do is it would authorize automated enforcement for crosswalk monitorings for vehicles that drive through the crosswalk when there's a pedestrian there. But there were several amendments. Firstly, the original bill had a $40 penalty. The amendments from the House set that at $65. Secondly, this committee and the General Assembly did great work on data privacy protections last year for these automated enforcement violations. So we added these automated enforcement violations to the provisions of Senate Bill 381 that passed last session. We took amendments from State Highway related to if there's going to be signage on state roads, then that needs to be approved by State Highway. And then lastly, we added language that if there is revenue collected from the violations, that revenue has to go back into improving the infrastructure at the crosswalks. There were provisions in the differing local bills that were carried over And my hope, I know that those bills are with the respective Senate delegations over here, so if whatever the will is of the committee and those delegations, I will respect. And with that, I would respectfully request a favorable report of House Bill 938.
All right, thank you very much. Delegate, questions from the committee? Senator Sidnor.
Just help me to visualize. How does this work?
Yeah, so similar to speed cameras, automated enforcement, and I don't know if it's in the floor system, but I will share it with the committee. There's a really good example of what the technology will look like. But if
whose testimony?
The what?
Would be under yours?
I think it would be under Obvio's testimony if they're in there. But basically, if there's a pedestrian in the crosswalk, there's the automated enforcement device. The technology would detect that there is a person in the crosswalk and that the vehicle failed to come to a complete stop. And then that would go to a technician. Different companies may handle it differently, but the one company, Obvio, that I worked with on the legislation, would go to a technician, they would confirm it, and then it would, as with all other automated enforcement, go to a local police department to make the final determination if there was a violation there.
So the violation would be, all right, so if someone's you're saying they come into the crosswalk, my vehicle rolls into the crosswalk, maybe I stop when I see them, but because I've now entered the crosswalk, I would be penalized under this if the camera goes off?
We were actually having a lot of conversations about this. We don't do anything to adjust. It's a violation of 21502 of the transportation article.
Right, but nobody's generally going to be there to give you a ticket. You
Right.
stop when you see the person, you stop.
Right. If in that situation, I believe, yes, you would be penalized in that situation. However, I would say that it's always going to go to a local law enforcement official to make that final determination.
So my law enforcement department needs some money. We need some revenue because we need some body cameras and everything else. Your vehicle comes in maybe less than a half foot into it. The call is going to be to get that money, right?
Yeah, and I think, the bill as it stands right now, should it make it through the respective Senate delegations, is only Anne Arundel, Prince George's, and Montgomery counties. So not Baltimore County.
No, I go to church in Anne Arundel County.
Okay.
So, we travel.
Yeah.
Thank you.
Of course.
Following up on my colleague, I often probably glide into that by a foot or two. It is not to be dangerous, and I am so respectful, and I understand pedestrians, and I want them to, and sometimes I'm like, come on, I'm here, I just wanted to get my car a little turned over, but what you're telling me is I would then could be fined, or would be fined, because I technically violated, which I didn't even know, 21-5022, but now I'm going to be caught on camera, and any of half my wheel goes in by 6 inches, then I am going to get a ticket. And I understand law enforcement can make that call. I'm not sure this bill allows law enforcement to have that kind of discretion. I think if they see the violation, I don't see how they can decide not to enforce this particular provision.
Yeah, on page 14, lines 29 through 34.
Oh, hold up, I didn't get to 14, that's a lot. Oh, just give me 1 sec.
Similar to other automated enforcement,
Yeah.
the record itself is going to go to a local law enforcement department to make that determination. I will add a few other things if I can, Senator.
Yeah, because what I wanted to ask you, to hold your thought, if you're telling me that this has changed the law in a way that says law enforcement, bearing in mind the existence of 21-da-da-da-da-da, can make a judgment call as to whether or not there was any endangerment of the pedestrian, I would agree with you that law enforcement will make that call, and maybe they'll be understanding of what I just did and what I routinely do. But I don't think that's what you're saying happened on page 14, are you?
So if I can.
Yeah.
I think the point I'm trying to make is that under current law right now, under the 21-502, law enforcement has that, it's ambiguity in the law. And they have that ability right now to make that judgment call.
I'm sorry, what's the ambiguity? You lost me. What's the
I'm saying right now,
ambiguity?
under that 21-502, they have the ability to make that judgment call,
Make what judgment call?
whether or not this situation that you were talking about, a person violated 21-502.
Okay, I'll look that up.
What this bill would do is create the automated enforcement process to then it's ultimately always going to go to a local law enforcement official
Right.
So am I answering your question?
You are, and then I have to go and look at that particular statute or regulation and see whether it says something like, it may or may not be a violation depending on how I entered it and what other conditions were existing and how I did or did not potentially endanger someone in the crosswalk. I don't know what the statute says or the regulation says. Do you? Verbatim?
Not verbatim.
Yeah, well, that's the point.
Yeah,
You'd
yeah.
have to know that.
But I think the other point that I did not mention in my original testimony is, I think the other important part of this is the educational component that goes in prior to putting these forth, and I think that helps alleviate a lot of the consternation about violations as well.
It's a long bill. Read the whole thing, but thank you for the question.
Yeah, of course,
And I appreciate how you brought it and how you present it. I really do. Thank you.
Of course.
All right.
All right. Further questions from the committee? All right, thank you very much. With that, House Bill 938, that concludes the hearing for that. We're going to go into Delegate Embry with House Bill 1311.
Thank you, Chair, very much. It's nice to be back again. Always a delight. Yes, thank you. I hope this will be a quick bill hearing. So I sit on the Prison Education Commission along with Delegates Pasteur and Simpson, and this bill is a recommendation of that group. As there's varying reports, but there's very strong consistent data that providing higher education to inmates is one of the best ways to reduce recidivism. There was a RAND study that was a meta-analysis that showed a 43% reduction. There's lots of other studies, but clearly a benefit. And I know this committee knows that. So the question is, how do we get more inmates into higher education? And this is one way is to make it easier and help the schools help the inmates, and then the schools that are active in providing education in the prisons pay for it, because that is one of the key obstacles. And so this bill clarifies, so it is not currently under law prohibited, but it is not, the law does not speak to this. It allows inmates to be eligible for state need-based aid. So that could supplement Pell Grants that they're already eligible for. It doesn't give them an edge, it just means that they're eligible. There may be criteria for that need-based aid that they don't meet, and then they wouldn't be able to get it, but the fact of their incarceration would not disqualify them. It does that, and then the second thing it does is it adds, currently DPSCS is directed to assist inmates with Pell Grant applications and obtaining that resource, and this would add to that. So they would actively assist inmates and the schools that, again, are active, like Goucher, University of Baltimore, that are doing this work. And so there's no fiscal note. It's supported by the university system, it's supported by the community colleges, and so I hope you will report it favorably, and thank you.
Thank you very much. The question that I have in looking at this, the thought was, all right, so they'd likely be eligible for senatorial and delegate scholarships. The question, though, is under whose address? I mean, and now you probably haven't given this any thought.
I have given it no thought, but I love the question.
Yeah, so I mean, they go to Western Maryland or the Eastern Shore, or maybe even Baltimore City. Would you, I would assume you would probably use the address of last resort prior to being incarcerated. I'm curious, this is your bill,
Yeah.
what would your thought be?
I have not thought of it, and I would happily, I'll talk to MHEC, and I'm happy to research that. I'm also happy if that would be an amendment that you would want. I'm happy to provide that. Thank you for the question.
So further questions from the committee? All right. Thank you very much
Thank
for your
you so
patience.
much.
Thank you. All right, with that, that'll end the hearing for House Bill 1311. Now go to Delegate Hornberger with House Bill 1370.
Afternoon, everyone. Mr. Chair, Mr. Vice Chair. Delegate Kevin Hornberger here on behalf of HB 1370, which is a local law enforcement bill that seeks to establish a pilot for stop sign cameras in the town of Rising Sun. This bill was brought to us by the Chief of Police and Mayor of one of my favorite towns in the district, as a proud graduate of Rising Sun, because the town is bisected by a state highway. On both sides of the state highway, you have residential areas with stop signs. They have very limited law enforcement resources because it is a small municipality. And they've seen this work in other jurisdictions that are currently authorized, such as Montgomery, Prince George's, and Tacoma Park, and want to emulate that as opposed to raising taxes and bringing on more officers to basically monitor these intersections. So we have unanimous support by the delegation. We're asking for a favorable report on this local bill, and happy to take any questions.
You know, I'm surprised to see this come out of your jurisdiction.
As am I.
I am shocked.
As am I.
It's no, I guess I don't have a question. I'm just shocked.
Well, I'll share a personal anecdote. I was completely opposed to this idea when it was brought forward.
Yeah, that's how I'm feeling.
And our chief of police made a very compelling and succinct argument of why this is necessary. We have our playground on one side of the community, again, that's State Road in the middle, and then we have our middle school on the other side. These streets, unfortunately, the perpetrators of running the stop signs are residents and their guests. These are not roads that are traversed by outsiders. You know, you have to have a destination in mind when you're doing this, and they're habitual offenders, and they just don't have the resources to curtail the behavior. We've also directed the town to work with a nonprofit that'll administer this program so that it is a deterrence and not a revenue generator.
Wow.
Yep.
And how long is the pilot program for?
For 3 years.
3 years, and you're collecting data?
We'll start off with a town hall, whereas they'll brief the town on the locations and whatnot. And then my understanding is that the first few months will be warnings. And after the warnings and a time period has gone by, it'll transition to actual fines of no more than $40.
But I mean, if the program was ongoing, I would assume.
Yeah, we would have to come back and extend the sunset.
So you want to be collecting some sort of data to show how effective? I mean, does the bill call for that?
Yeah, that is actually a functionality of the nonprofit. So we're not specifying that in the bill, but yeah, that is.
But that would be the expectation under the contract.
Yes.
Thank you.
Thank you. Great question.
That is exactly my question, was I don't see any reporting required in the bill. And if it's a pilot and you anticipate coming back and asking for an extension, would you consider putting reporting in there?
Yeah, we're fine with mandating that. Again, this is at the discretion of the town. Originally, this bill was drafted to mirror language for Prince George's, which included a county council approval. And our council and executive, although supportive, thought that this should be more of a town initiative. In other words, their council, their mayor, administered by them. So I'm happy with giving them that discretion. I'm also happy with including it in the bill.
Sure, but if you anticipate coming back and asking for an extension of a pilot, we're going to need something to understand
Justify.
why you want the extension.
Yeah, we wouldn't be opposed to that.
Thank you.
Thank you for the bill.
Yep.
You left. Is there data for supporting such an act, like crash data, pedestrians being struck, anything like that that's?
Sure. So the genesis for this was driven by complaints in the community. They posted officers at these intersections, and they were able to catch and ticket numerous individuals. However, they don't have the resources to post someone at these intersections at all times. So this is more anecdotal.
I understand. So, but my question is that at the times when the officers aren't there, is there data to support such a measure, like injury data, crash data? Is there anything that's happening at this intersection that's rising to the level that we need Big Brother watching? I'm always about data. Like, is there crashes occurring? Is there things that are supportive of this? And I don't hear any of that happening.
So the nature of the bill is a pilot, and that information would be gathered at the beginning of the process, right?
But it should be at the beginning of of your ask.
So this is following a similar procedure that other jurisdictions had luck with.
Okay.
in the state of Maryland.
All right, I'm just, thanks.
I get the chicken and the egg argument.
Yeah, I'm
here.
not,
But we have to start somewhere, and heaven forbid,
I'm going to
someone's
remain
child-
consistent, and I'm consistently opposed to these type of measures.
Of course, I was
Thank you.
too.
Yeah.
What I will say, just
Until today.
speaking generally, is all of us come down here with beliefs and thought patterns and stances. And then someone comes along from our community or a peer or a loved one that knows us and presents a problem, and in some cases presents a solution to that problem. And at that juncture, we have to take it upon ourselves as representatives of our community to say whether or not that's a good idea and that should be able to proceed. And in this instance, I was completely opposed. I'll go on the record as saying that. But after it was explained to me that a simple $40 fine, a warning at the beginning, can save a child's life, can make our community safer, and if it goes awry or turns into something it shouldn't be, it can be turned off. I have to bend my beliefs and go along with the locals that are there that are trying to implement the laws. I mean, in no way, shape, or form am I going to be someone that's going to advocate for someone to break the law. And I know you as a law enforcement individual would probably feel the same way.
I do. I like to have data to support such a matter.
Yeah, and I support the gentlelady's recommendation that there be a reporting requirement in there as well.
Thank you.
All right, thank you both. With that, seeing no further questions, that'll conclude the hearing for House Bill 1370.
Thanks, y'all. Have a good one.
I appreciate it. All right, with that, we're going to go on now to House Bill 921 with Delegate Moreno.
All right. Good afternoon, Chair Smith and members of the Judicial Proceedings Committee. For the record, I am Delegate Gabriel Moreno, and I am here to ask for a favorable report on House Bill 921, Juvenile Law, Confinement, and Restrictive Housing Limitations. This bill unanimously passed out of Judiciary Committee and passed the House of Delegates by a 104-31 bipartisan vote. HB 921 arrives in the Senate heavily amended from its original version to conform to flexibility requests from the Department of Juvenile Services. HB 921 now simply alters the regulatory requirements that DJS must adopt, addressing how minors are allowed to be placed in restrictive housing and confinement spaces. Under HB 921, DHS would be required to adopt regulations that prohibit locked door seclusion and restraints as a form of punishment for convenience, as a staffing substitute, or in retaliation to a youth misbehaving. It also limits the use of locked door seclusion only when there is an immediate or substantial risk of the harm to the child, other youth, or staff. If locked door seclusion becomes necessary for the purposes just stated, it must be trauma-informed, developmentally appropriate, and time-limited with visual inspections and both a medical and behavioral health evaluation within the first 30 minutes of that seclusion. Water, food, bathroom access, and other necessities must be met as well. HB 921 reflects a growing recognition that youth are fundamentally different from adults in both development and vulnerability, and that our policies must reflect that reality to ensure both physical and mental safety for our youth. By modernizing our approach around confinement and restrictive housing in DHS, Maryland can better protect our most vulnerable youth while maintaining facility safety. For these reasons, I respectfully urge the committee to issue a favorable report on House Bill 921. I am happy to answer any questions. I also have DJS present and also James Dold from Human Rights for Kids in the room for questions as well. Thank you.
All right, seeing none, thank you very much.
Thank you.
That'll conclude the hearing for House Bill 921. I'll go on to Delegate Young. Is Delegate Young here with House Bill 1569?
I was here first, Mr. Chair. I've watched all your jokes today. Colleagues, Senators, Delegate Young here on behalf of House Bill 1569. This is the easiest bill of the day for you all. I say that with conviction. I'm going to simply read, my testimony will simply be from the synopsis on the fiscal note. It's that simple, and I think if I say anything else, it's going to complicate it. The bill establishes that if a parking citation is issued for a motor vehicle while it is in the custody or control of an auto repair or storage facility, the auto repair or storage facility, and not the registered owner, may be held liable for the parking citation, as well as associated fines and late fees. The bill prohibits an auto repair or storage facility from requiring a customer to waive their rights established under the bill as a condition of service. The bill does not limit the authority of the parking enforcement agency to enforce parking laws under its jurisdiction. I urge a favorable report.
Actually, you can go ahead and get yours first. I'm still finishing up the one letter. Thank you.
All right. So, all right. So this bill actually something that you can use if you've been ticketed then. If I'm just quickly looking at it, it's an affirmative defense.
That's correct.
All right, so it's not as if the law enforcement has to know that it was in the custody of the auto dealer or...
No, you would get the ticket as the owner, as normal. The
Right,
law
then you go
enforcement
in there
officer-
and then you argue and you show the receipt that it was in possession. That's what you're thinking?
That's correct. And then the law enforcement officer, if they so choose, can go and get the same citation done on the facility.
Thank you.
Yes, sir.
Thank you. I'm just curious, I was looking at the self-storage, their letter talking about the shifting of liability, but on the self-storage areas, they're mostly like contained inside of a fenced area?
That letter offers an amendment, which we accepted. So what's before you today includes the amendment, and they withdrew their unfavorable report.
So we have a reprint. Okay, thank you.
Further questions from the committee? Seeing none, thank you very much, Delegate.
Thank you. Y'all have a blessed day.
You too. All right, with that'll conclude the hearing for House Bill 1569. We'll now move on to House Bill, our last bill today, 1630. We have Aiden Peters is going to present.
Good afternoon. Good afternoon, Chair, Vice Chair, members of the committee. For the record, I am Aiden Peters here representing Delegate Stephen Ahrens. He apologizes he cannot be here due to his own committee and session meetings, but he doesn't extend an apology to you all. Nonetheless, I'm here to present House Bill 1630 as amended. This bill establishes, for the purpose of authorizing the State Highway Administration to place and control speed monitoring systems on U.S. Route 301, approaching the intersections between Maryland Route 405 and Route 19 in Queen Anne's County. In the Maryland Route 405 crossover with Route 301, there have been 66 crashes from 2020 to 2025 alone. The frequency of these crashes is quite alarming, with 2 fatal crashes occurring within 3 days of one another, claiming the lives of 3 innocent people. Highway speeds have been consistently cited as the leading cause for these crashes. Implementation of speed monitoring systems in this corridor will provide Maryland motorists with increased safety in especially vulnerable stretches of our roadways, ensuring motorists slow down and exercise proper caution when traveling through intersections. Not only do these measures drastically reduce instances of fatal crashes, but will also encourage safer driving habits across the board. If we want to keep our Marylanders safe in these areas, we must prioritize the enforcement of important speed limit laws for the safety of our citizens. Thank you for your consideration, and I urge a favorable report.
All right, thank you very much. Questions from the committee? All right, seeing none, thank you. Thank you. Have a great day.
You as well, thank you.
Oh, sorry, no? Oh, no, okay. All right, thank you for that. All right, with that, that'll conclude the hearing for House Bill 1630 and our hearings for the day. Enjoy some of this weather.